Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. You, as jurors, are the sole judges of the credibility of the witnesses and the weight their testimony deserves. You should carefully scrutinize all the testimony given. In weighing the testimony of each witness, consider the relationship between the witness and the parties in this case, his or her interest in the outcome of the case, his or her opportunity to observe or acquire knowledge concerning the facts about which he or she testified, and whether the witness impresses you as having an accurate recollection of these matters, the witness's manner of testifying, candor, fairness, and intelligence, and the extent to which the witness's testimony has been confirmed or contradicted, if at all, by other credible evidence. You will rely upon your own good judgment, your own common sense, and the experience you have gained as you have gone about your everyday affairs in weighing the evidence and determining the weight to be given to it. You are permitted to accept as true and worthy of belief everything that a particular witness may have said, or you are permitted to reject everything that a particular witness may have said. Of course, you may also accept as true part of what a witness tells you and reject other portions of that witness's testimony. The testimony of a single witness may be sufficient to prove any fact, even if a greater number of witnesses may have testified to the contrary, if, after considering all the other evidence, you believe that single witness. You should keep in mind, of course, that a simple mistake by a witness does not necessarily mean that the witness was not telling the truth as he or she remembers it, because people may forget some things or remember other things inaccurately. So if a witness has made a statement, a misstatement, you need to consider whether the misstatement was an intentional falsehood or simply an innocent lapse of memory, and the significance of that may depend on whether it has to do with an important fact or with only an unimportant detail. All right, let's see what we have for some literary practice. Ready? Here we go. The monsoon clouds began to break up, and the high desert expanses of Arizona's Verde Valley suddenly glowed golden under the late afternoon sun as my wife Becky and I drove the final stretch toward Cottonwood. When I first visited more than 20 years ago, the town slumbered steps away from the forest that traces the course of the Verde River, while the old mining community of Jerome, a few miles up the road, was a tumble-down ghost town. And nobody was thinking of raising wine grapes in the Verde Valley. Now, Cottonwood is a foodie hot spot. Jerome has sprung to life, and nearby Clarksdale offers compelling attractions. Wow, this place is totally different from what I remember as a kid, said Becky, who used to come out from New Jersey during summers to visit her grandparents in nearby Prescott. Exploring the Verde Valley reveals a sometimes overlooked part of Arizona where timeless landscapes find an easy balance. All right, back to some jury charge practice. Ready? Here we go. You may, in your determination of the facts of this case, consider both direct and circumstantial evidence. Direct evidence is the testimony of a witness who actually saw an event occur. Circumstantial evidence is proof of a chain of circumstances pointing to the occurrence of a fact or the existence of a fact. Direct evidence includes a witness's testimony as to facts within that person's own personal knowledge, matters that the witness saw and heard, and matters that came to the witness out of that person's own senses or observations. Circumstantial evidence, rather than or in addition to direct evidence, can be used to establish a fact if that fact may be fairly and reasonably inferred from all other facts and circumstances proved in the case. In order to establish a fact or conclusion by circumstantial evidence, the facts that were directly proven in the case must be such as to make the fact or conclusion sought to be shown by circumstantial evidence more reasonably probable to be true than other facts or conclusions. As a general rule, the law makes no distinction between direct or circumstantial evidence, but simply requires that the jury find the facts in accordance with a preponderance of all the evidence in the case, both direct and circumstantial. You must answer all questions based on a preponderance of the evidence. A preponderance of the evidence means the greater weight and degree of the credible evidence admitted in this trial. It does not necessarily mean the greater volume of evidence or the greater number of witnesses. To establish or prove something by a preponderance of the evidence means to prove that something is more likely true than not. In other words, a preponderance of the evidence in this case means such evidence that, when considered and compared with that opposed to it, has more convincing force and produces in your minds a belief that what is sought to be proved is more likely true than not. All right. We'll try some more literary practice. Let's see what we have here. This is an article from one of our NCRA magazines, and it's called What to Do with Those Old Steno Machines. Ready? Here we go. Steno machines are no different from anything else in life. At some point, they need to be replaced. But what's a reporter or captioner to do with their old machines? For some, the answer is to donate them to a court reporting program. A donated machine is very much appreciated by a student, says Mary Beth Johnson, CRI, a professor of court reporting at the Community College of Allegheny County. Our school is located in Pittsburgh, Pennsylvania. We live in an area where court reporters are very generous. Our students have been the beneficiaries of donated steno paper, machines, and thousands of dollars in scholarship monies. As a teacher, I am always appreciative of the court reporters, she adds. State court reporting associations also recognize the importance of donating old steno machines and other items to benefit students. Recently, both the California Court Reporters Association, CCRA, and the Wisconsin Court Reporters Association, WCRA, issued calls to their members to donate old machines to schools and to volunteers who are leading the A to Z program, a free introductory course of basic steno for those who might be interested in pursuing a court reporting or captioning career. In Wisconsin, I know of several reporters who donated their steno machines to the court reporting schools and also to the A to Z program, says Sherry Pointek, RMR, CRR, CRC, an official from Green Bay and president of WCRA. All right, we will stop there. That will conclude our literary and jury charge practice.